The Power Hour will be the first in a two-part series covering repair amendments. Our intent for today's program is to start with initial repair amendments and lender-required repairs, property disclosures. We anticipate that there's going to be many questions that are going to be asked through the chat feature. Some will be able to answer today, and others will be covered in our next session on June 18th at the association meeting, where we will dive more deeply into repair amendments. Joining us today, though, is Tracey Gerard, managing broker, Ryan Tucker, and loan officer Matt Wilkerson, and attorney Jim Manning. So let's get started. Our first question is going to be for you, Tracey. Let's start with the initial repair amendments. When do you use an initial repair amendment? Why is it a good idea?
I use initial repair amendments a lot. Anytime I see something that is broken, there's no reason for me to wait until an inspector tells me. So anything that would be cosmetic, such as broken siding, missing gutters on a house, a broken window pane, anything like that, you can use the initial repair amendment. Those are things that are not going to be considered to be contractual in the repair amendment after an inspection, because it's really obvious before. So if I want something like that fixed for the buyer, we're going to talk about it at the very beginning and say, we're offering this much and we're asking for this many repairs right off the bat. It just seems more fair to the seller to go in with, these are the things we're going to want fixed, and this is how much we'll give you for the house if you fix these items. I will also use them for, I just did one. So I'll just give an example. I just did one with an offer that had, you could see that the driveway to the house slopes a little bit, and you can see where they have caulked it and concreted it there, but it was old and broken and it definitely needed to be resealed. So I asked to have that driveway to the house resealed. I could also see that because of those issues, there were some bowing walls in the basement, or that wall exactly was bowing. So I asked to have that braced with the initial offer. So, and we came to an agreement. It worked out perfectly. We haven't closed on it yet, but we're getting ready to close on it. So it worked out really well for the seller and for the buyer to just go ahead and say, we can see there's a problem, and let's go ahead and address the problem with the initial offer. Then I will also use it if I have a VA loan or an RD loan or something that I can see right away. There's some things that an appraiser is going to call out, missing handrail, peeling paint. If I see those items, then I'm going to just ask for it with the initial offer. And at that point in time, I do ask to change the days. Right now, our initial repair amendment says that they need to be, the repairs need to be completed 5 days prior to the closing. I do ask for it to be completed in a week after the offer, so that it is completed before an appraiser goes through. So that way I'm trying to protect my buyer from having an appraiser have to come back through, and let the sellers know right up front, we already know these issues are going to be called out, so let's just get them. That even includes like a CO detector, a fire alarm. If I don't see them, a smoke detector, CO detector, I'm going to say, can we go ahead and get those in there before the appraiser comes through, just to avoid all those issues that are going to come up later. Anything that we can avoid, that's what I feel like the initial repair amendment is for. If you can avoid later problems, just go ahead and hit them right at the beginning with your offer.
Okay, and so we would use that additional amendment box on the contract to kind of notify.
There is an amendment that is called initial repair amendment.
Right.
So you're going to definitely check that and include it with your offer. Include that report with the offer.
Okay, great advice. Are there specific things you check for in every house when consider writing a repair amendment?
I do check the electrical box. I know that most of us know that the Federal Pacific electrical boxes, a lot of them have recalls, or if there's old fuses in a box, I immediately automatically put that in with an offer to go ahead and upgrade that electrical box so that that doesn't come up later. That's one thing I always check for. I always look for gutters on the house, because those are those things that you miss sometimes. And then just your basic broken anything.
Okay. How about you, Ryan? Do you have specific items you check for?
I don't, I mean, I have a list, I guess I check for, but a lot of times I like to have, and I wrote down just a couple examples. So, um, when I'm working with a buyer, specifically ask them what are some items that you guys see that you may want fixed or addressed, because there's a good chance that those items will come up in the inspection and they won't be contractual and we won't be able to put them on the 14-day repair amendment. And that actually usually spurs the next question, which we always try to educate them as much as possible. But well, what can we put on the repair amendment, right? Well, here's some things that you can't really put on there. The doorbell that doesn't ring, things like that, right? Install a screen door or removing paint cans. That's something that always seems to come up with. There's a bunch of paint cans that are there because it's old paint, and inevitably it's left there. And next thing you know, at final closing, they're saying, "Hey, where's this paint? You know, who's taking this paint?" So when I see a bunch of paint and they don't want it, I write it up on there. I know it's a repair amendment, but it's a great opportunity just to write it down and say, "Hey, have them remove this stuff," because a lot of times it doesn't, I guess, fall on the within the contract to remove the paint, right? Um, so a lot of times it's a great opportunity to actually educate them on what can go on the 14-day repair amendment. And then is there anything that they've seen that won't be contractual that actually we can put on that initial repair amendment? So.
Okay, great. Jim, I'm going to throw this one to you. When does the work, I know Tracey said that she has a suggested time frame that she wants that work completed for appraisal purposes, but when does the work need to be completed for items on an initial repair amendment?
Well, it's the same as the inspection repair amendment following your inspections, in that all of the repairs and other items that you've asked to be addressed need to be done 5 days before closing so that the buyer can go back in and make sure it was all done. So that's not something, and just because it's initially submitted with your offer doesn't mean that, well, this work has to be done in the next 14 days. It's 5 days before closing, just like the other repairs.
Okay. So what if a seller does not follow through on the initial repairs?
Well, I would contemplate in most situations that the repairs are probably all going to be done at the same time. And if a seller doesn't do it, it's the same way. If you're 5 days before closing and electrical or plumbing or heating and cooling work wasn't done, you give the seller notice that they're in breach. And it's the same remedy for both the initial repair amendment and the inspection repair amendment. So the seller's technically in default if that work isn't done. So the buyer can provide them notice, opportunity to cure. If the work isn't done before closing, then just delay closing until the work is done.
Okay. Ryan, I'm going to go back to you and ask, how specific do you think you need to get?
I personally say very specific, and just to kind of piggyback on what Jim was saying, there's times that I like to even change or have it changed. You gotta be careful not to act like it's a lawyer, but there's certain things that I would love to have fixed or addressed prior to the appraiser showing up, like an FHA or a VA appraiser. If there's certain things that we know are going to come up on that appraisal inspection, write it up on the repair amendment, initial repair amendment, and ask that it's done prior to that appraiser showing up. So it might not fall within that 5-day window, if that makes sense.
Yeah.
Yeah.
Okay, that sounds good. Matt, this one's for you. As far as asking for cash or a credit on the initial repair amendment, how would you like that handled?
Yeah, so in the lending world, the term cash makes us cringe. So we want to stay away from cash. We want everything to be documented to make sure that it's not coming from an interested party. And, a lot of this, and when we explain it to our customers, is, a fallout from, back in the last financial crisis, 08, 09, where there was, money going from seller to buyer for part of their down payment, or sometimes luxury cars or whatever. And then prices were being inflated and appraisers were inflating the values. And then all of a sudden the bottom fell out and there was no support for where the values were. So the whole idea is that, they've set guidelines for what the seller can contribute to the buyer. And it's different for every loan. But if it falls outside of that allowed contribution, then basically they want to lower the sale price. Otherwise, it's seen as an inducement to sell, and that's where they run into a problem. So just kind of like a general rule of thumb, if there's a negotiation on a repair and they want to issue a credit, that can go towards the loan closing cost and prepaids, which in general is going to be 3% on most conventional loans. It's going to be 4% on a VA loan, and then up to 6% for FHA and USDA. And you can maximize that credit to offset any costs that are closing costs or for prepaids, which would ultimately lower the bottom line that they need at closing. And then another alternative is to negotiate the seller to make those repairs and have those paid out at closing. So, on a conventional loan, if it's a flooring issue and this is negotiated back and forth, it is okay for the seller to, pay an invoice directly to XYZ flooring company to have that taken care of, as long as the seller's paying for it and it's on the settlement statement. So.
Okay.
Well, Matt, if it's work that's the seller's not going to do, they're just going to, I've got one today, I just found out, seller's going to give the buyer $1,300 for some kind of drainage issue, and I don't know what that is. I'm guessing something out in the yard. You would rather see that as a closing cost credit than a credit in lieu of repair on the settlement statement?
Correct. So they're going to want, typically we'll show it as an update on the financing amendment for seller concession. It does vary a little bit from lender to lender, and as long as, if it just says seller credit and it's within that allowable percentage, then you're good.
Okay, great. So
But are you going to want to see an amendment to the financing amendment, though, to show that as a closing cost credit?
Correct. Because that also has to be reflected on the appraisal. If there's any seller credit or concession going back to them, it may used to make us send it back, get the appraisal updated and everything before closing, and it could, often delay closings. Now a lot of underwriters have the discretion to go in, just make that change, send it back to closing, and you're good to go. But they do want documentation of where the credit's coming from and making sure that it falls within the allowable range.
Okay.
Yep.
Okay. So really, to summarize that initial repair amendment, it's really going to save time and money, and it sets the expectations for everyone to be on the same page, and it's good communication for both the buyer and the seller. So let's move on to lender required repairs. We've kind of already touched a little. Matt, how will I know if the lender is calling for a repair?
Yeah, so, this gets a little tricky, and it does a lot of times depend on, the appraisal. I guess the first thing I would say is, so when you talk about what the lender is going to require, it can vary from lender to lender. So there's overlays. So one thing I want to make sure everybody knows is it's never like one size fits all, right? I wish everything was, black and white, but that's not the case, because what you have is for the GSEs, so Fannie Mae, Freddie Mac, and then FHA, VA, and USDA, there's a handbook that has guidelines that they find acceptable. But then every lender has certain overlays as to what they will require and what their risk tolerance is. So, there's a lot of lenders, for example, that may say, we need a termite on every FHA loan. Well, that's not in the FHA handbook. So it's not necessarily an FHA guideline. It's an overlay for that specific lender that says, I don't want any blowback on me that we didn't do a termite inspection. So it's pretty common that all lenders on FHA loans do want that termite inspection. But as far as repairs, most of it's going to come down to the appraisal. The appraisal is the eyes for the lender, and basically, underwriting, they never see the property, they never go out to the property, they order the appraisal, and they're relying on that appraiser to make sure that it falls within the guidelines of, Fannie Mae, Freddie Mac, or HUD, VA, within their guidelines. And then they're going to review the appraisal and say, hey, the appraiser has, noted that this needs to be repaired, right? So on especially your government loans, they're looking for safety concerns, and peeling paint, chipped paint, broken glass, exposed wiring, handrails. So if you go into that property seeing those things, you can prepare your seller or buyer. These are likely going to need to be addressed. But again, we're not going to flat out call for those because we've never been to the property until that appraiser goes out, and that can be subjective. It's amazing. Been doing this a long time. Some appraisers go and walk through a house and, you'd think paint was falling on them and nothing comes back in the report. And it's like, okay, how is that possible? And, other ones seem like they have the magnifying glass out going from corner to corner, just looking for a speck of paint. So I would just say, keep a close eye on, your appraisal contingency. Once that appraisal comes back, we're going to review it. Underwriting is going to look for any repairs, and one of two things is going to usually happen. They're either going to follow up and ask for certain repairs or ask for further inspection, which I think we're going to touch on here after a bit.
So we have a question for you on what happens when the buyer is maxed out on closing cost credit and then the seller offers a credit in lieu of repair. Can the buyer not accept it?
So it's not that they can't not accept it, but it's going to have to be in a reduction of the sale price. So they can't have excess credit above that because that's where it falls into the inducement of, to purchase. And it's seen as excessive that they would be giving a max credit back in excess of that amount. So instead, you should lower the sale price because they've got requirements that they still want minimum contributions from the borrowers for a down payment, and they don't want that to get offset by the the credits being given to them for said repairs. So it's either seller makes repairs, seller has them paid at closing for the repairs, they give a credit within the allowable percentages, or then we're moving into lowering the sale price when you get in excess of those repairs.
So who can make the repairs?
It's a good question. So, a lot of times they'll ask for, a licensed contractor, to make the repairs. But again, that's going to be a little bit of underwriter and lender discretion on how detailed they get on it. So, we've had properties where, the seller gave permission for a buyer to go over and, do some exterior painting. They did the exterior painting, and our only requirement was to, order a final inspection to verify it was completed. But if you get into, I guess, bids being done at closing, and, roofs being repaired or major things on the house, they're typically going to want a licensed contractor to complete those repairs just to make sure that it was done, correctly and that the collateral is sound.
So how do you feel about escrow? That brings up that.
Yeah,
Is there ever a moment that you're okay with it?
Yeah, escrows can be okay. A lot of times it falls on, what's the reason that it can't be done within a timely manner. And so if it's a weather related issue, that's usually acceptable. If we've had septic repairs that have been escrowed because of how backed up they were to get some of the work done, but it was still functional, It was just recommended repairs. And so we have not seen too many issues with escrowing for those repairs. It's usually allowable, as long as it's, reasonable and also within a set percentage of the, cost to cure on the appraisal that they call out, if it was called in the appraisal.
Can the buyer pay for a repair on the closing statement?
Yeah, as long as the funds are verified and they have the ability to pay for those, then that's perfectly fine. And again, underwriting is going to probably look at it and say, hey, is this any kind of safe or healthy concern that would pose a risk? Some lenders, don't like they want the radon mitigation retested before closing because they want, absolute certainty that the system worked and they're not putting a client or a person in harm's way, right? And so I think a lot of it comes down to just, making sure that we're not putting anybody in a position that's going to, be detrimental to their health or whatever, that somebody's going to come back and be sued over something, saying that you were negligent or you didn't, look at the best interest of the customer and their safety and health.
Okay. So another question we have is it still okay for a seller to pay a contractor on the CD for work to be completed post-closing then?
Yeah, I mean, we haven't run into an issue with that. That's fine. Again, as long as it's not, well, I guess if you're paying it, the work's been done and we've done the final inspection. And as long as the funds are verified to cover them paying that, that's okay.
Okay. So you kind of alluded to this, but will the appraiser come back to verify the work is done? And how soon should that happen?
Yeah, so this can obviously come down to the wire and pose some delays with closing. So I think this is really important. But the standard process for all loans is basically if that appraiser calls out any deficiencies in the property or items that need to be repaired, then they want that appraiser to go back out and update the report to show that those have been completed. So that doesn't get into the 3-day appraisal waiver on the final inspection, as long as nothing valuation is changing with the report. So I mean, typically, as long as we get that back within ideally 2 to 3 days before closing, it's fine. A lot of times what we're trying to do is, a lot of this all just comes down to communication, right? Like if we can stay in constant communication throughout the transaction and, you communicate, hey, our contractor is going to be out here on XYZ date, it will be completed, then let us know. We'll go ahead and schedule it through our appraisal management company to be, after that date, so that the appraiser can get it on his schedule and we've got all the, pieces moving forward. But again, I think there needs to be a reasonable expectation that, we want to have those repairs done a week before closing at minimum, to allow time for that appraiser to do the final inspection, get the report turned in, reviewed by the AMC, and then cleared by underwriting.
So who's responsible to pay for appraiser requested additional inspections? If the buyer didn't voluntarily ask for that inspection, it was requested because the possibility that particular item is in questionable condition, who's responsible?
Yeah, so we talked about this in the education committee, and seems to be kind of a varying difference of opinions, and maybe Jim can weigh in here. I will tell you, like, in majority of the cases, our buyers pay for that final inspection because it is a cost for getting the loan and it's a requirement for the loan. Mm-hmm. That being said, could it be negotiated between buyer and seller? I don't know. And I usually let the agents handle that. I just know that it's an expense that's incurred and required for loan approval and to get the financing.
Do you have any comment, Jim, on that?
Yeah, I'd agree with Matt. If you're talking about the cost of the appraiser coming back to inspect, that's going to be on the buyer. The contract, the lender's inspection repair amendment will only obligate the seller to the cost of repairs, not to the lender's appraiser coming back out. So if there's another fee, that's going to be on the buyer.
Okay. So let's get the lender and the attorney's opinion on this. What happens if the seller will not make the repairs? Matt, let's start with you. What happens if the seller won't make the repairs?
So if it's a required, repair that the appraiser called out in his report, then it's going to have to be completed for the financing to go through. So I guess that's the seller's, maybe choice, or depending on contractually if they're bound by the contract to make those completions. But again, that would put the financing at a standstill and the deal in jeopardy of falling apart.
Okay, Jim, is that so is that a financing cause of termination that would happen?
Yeah, absolutely. Yeah, we've added that provision in the financing amendment to notify the seller that there might be a lender's inspection. So in addition to, the 14-day inspection, the seller's put on notice that, we still might have some additional repairs depending on what the appraiser says. So at that point in time, you're going to use your lender's inspection repair amendment to submit those additional repair requests, but the seller has no obligation to make those repairs. All the contract essentially does, it enables the buyer to request those repairs. And if the seller is not willing to do those repairs, then the buyer has a way out. Unfortunately, though, for the buyer, they'll have, some costs. All they're going to do is get their earnest money back, but they're going to have costs involved with the previous inspections they did, whatever fees, for example, the appraiser's fee with the lender that they might have to pay back. But I think the first option probably is if the seller says no, while recognizing that, well, I might lose this sale then. And if it's a big enough deal for the seller to let the buyer go have his earnest money back, I guess they could do that. But then you shift over to the buyer and give the buyer the opportunity then to, well, if it's relatively minor, if it's a couple $100 and the seller won't do it, maybe the buyer will have that done. If it's a matter of, going and doing some painting, the buyer can do that himself or pay for a minor repair. But at the end of the day, if they can't come to an agreement, seller won't make the repair, buyer doesn't want to make the repair, well, then the buyer's only option is to terminate the contract and get their earnest money back.
Okay.
And Laura, I think a best practice on that, and I've talked to several agents on this, is just, again, the communication and expectations in the beginning. If your seller is willing to, accept VA, FHA government financing, let's get ahead of this a little bit and talk about some of the things that could be called out that are safety concerns and that may be called out as a requirement from the lender to be repaired. And same thing on the buyer's side, saying, hey, these are some things that could be called out, but may not. It's not a guarantee. So that might be something in the beginning that you put on that repair amendment if it's a deal breaker for the buyer. Don't just rely on the lender to say, oh, they're going to catch these GFIs, so don't worry about writing it in. If it's something they want, write it in, and don't just be dependent on an appraisal to call out repairs.
Okay. We have another question in the chat room. Let's say the scenario is that a home is being sold as is where is, inspection is done, and septic inspector finds that the whole system might need to be replaced, and the buyer cannot afford the repairs. On top of it, home is in the county that will require the repair upgrade to be sold to the next owner. Does this become a disclosure item? Asking only because I don't believe code issues are disclosure items, but it's a big issue and stops the sale from going forward. That's Jim.
So
Sorry.
the septic system is in reasonable working order, but the code requires an update to the system. I think that's what Stephanie's question is. If that's the case, it's not a disclosure issue. Seller, I don't believe, would have an obligation to replace or upgrade the septic system for this buyer because it's being called out, by the lender.
In this case, Tazewell County would most likely not allow the sale to go forward, completely blocked. Like, that's a huge issue. And before another buyer gets into contract without knowing, oh, this already didn't go through once because there's a $15,000 system that may need to be or needs to be replaced depending on which inspector you ask because of discharge issues or baffling or whatever. I agree that it's functional, but when you're dealing with an issue where it can't be conveyed to the next owner because Tazewell County is blocking it.
Right. So I guess that leaves the seller with the option of terminating this contract and just not selling the house, or realizing that if I need to sell, I'm going to have to get it done for the next one. So that's a conversation to have with your seller, that it needs to be done. If they don't have the money to do it now, then I suppose you take the property off the market. But the seller does not have to make the repair, but he's going to have to be willing to let the buyer out and give the earnest money back to the buyer.
Or can I chime in?
Sure.
Yeah, Jim and Stephanie, I didn't realize, and I've ran into this myself, but I don't think the health department or anybody can actually stop the sale from moving forward. My experience has been, I just ran into one in Woodford County. We ended up closing on it and taking care of it after the fact. And the only thing that they could do was start to issue basically fines or penalties and basically put pressure on the homeowner, but they can't actually stop conveyance of the property to the new buyer, has been my understanding.
Okay.
Under the health code, it'll be required to be done. I think you're right in that they cannot stop the sale, but they can force the new buyer to address the problem. So does that buyer then want to assume that obligation post-closing? Probably not. You want to address it now and get it done, unless for whatever reason the buyer loves the house and wants to move forward and will let the seller off the hook. But the work will have to be done at some point in time. So it's up to the parties to negotiate who's going to pay for that cost.
I would assume another level of complexity would be the fact that if you're working with a lender that's requiring to see the septic inspection and then says,
yeah, can't
we're not
fund it.
lending on this, right? Okay.
Yeah. It probably depends, like, let's say you have a repo or something, and they're getting it for a really low price, right? It's all relative to, what the buyer's willing to invest into the property and take on the responsibility.
Right, absolutely.
Okay. So let's move on a little bit further into disclosure, Jim. I'm showing a house that my buyers have a lot of interest in and would like to make an offer. There's a little water in the basement. However, the disclosure is totally clean. How shall I handle that?
Between this morning and yesterday, I've gotten 3 calls about basement water problems.
Right.
And we had a deluge of water and flooding over the weekend and last week with the rain. And inevitably, it's not disclosed that there's a problem. The seller said, geez, that's the first time it's ever flooded, and it's not the case. So this is prior to writing an offer. I would use your initial repair amendment. First of all, I'd be very careful about even writing an offer on a house that's got water in the basement, depending on how much, where it's located, and if the buyer's, savvy enough to know where it's probably coming from and it's an easy fix, that's one thing. But if it's a major problem, I'd be very careful even writing an offer. Perhaps you let the listing agent know and ask for the seller to explain where it's at. I wouldn't put a whole lot of faith in that explanation from the seller, because they're going to say, oh, the downspout was off, or, it's never happened before, I don't know. But you're going to want to put that on your initial repair amendment and ask that be addressed. because you may not have the ability after your 14-day home inspection to come back and ask for remediation of water in the basement because it's not going to fall in those categories of the contract. So I'd ask up front for, and you're probably going to want to be relatively thorough in what you're asking for, and that the basement water situation be remediated with a dewatering system, or if there's a obvious foundation repair that needs to be made, maybe even have somebody go out there before you write an offer from one of these basement dewatering companies, and give you an idea of what they think needs to be done, so that on your initial repair amendment you're negotiating that up front.
Okay. What if they mark yes to question number 2 on the disclosure, that it does, and they don't give any explanation?
Same thing, I would address it with the initial repair amendment. I'd also ask for an additional inspection, because your home inspection may not cover that water situation in the basement. So I'd ask for an additional inspection to include inspection of the basement, to further investigate the cause of the water intrusion and what might need to be done to remediate that. So you're covering both sides of it up front with the initial repair amendment, and negotiating that into the purchase price, and getting the seller's commitment up front that they're going to address that problem. But then if you don't use the additional amendments or the additional inspections on there to ask for a specific investigation and inspection of the basement to determine where the water is coming from and how to fix it, then you could very well be out of luck.
What's the timeline for suing a seller who misrepresents on a disclosure?
That was part of my call this morning, because they closed a year ago in April. And so under the Real Property Disclosure Act, you've got 1 year to sue the seller. So it's 1 year from either the date of closing or the possession, depending on which occurred first. Sometimes you don't get possession for 2 weeks after closing, and then that 1 year doesn't start until you actually take possession if it's following closing. So you got 1 year under that Disclosure Act to sue a seller. But if there's some indication that the seller concealed a material defect, you might be able to sue them for fraud, what they call fraudulent concealment or fraudulent misrepresentation, to maybe get around that Disclosure Act and have a different cause of action, which is going to be, I think that's going to be a 4 or 5 year statute of limitations for fraud. Way more difficult to prove that the seller concealed a certain condition and hid that from everybody prior to closing. But by and large, it's going to be 1 year for a failure to disclose a known material defect.
Mm-hmm. Okay. So I have a listing that goes pending, and I have a home inspection, and there are many material defects that are discovered, and the buyer cancels the contract. The seller then refuses to change his disclosures. What do I do as the listing?
Seller's already agreed to let the buyer out of the contract, because I think the buyer has to ask for repairs first, but assuming that you couldn't negotiate repairs, seller lets the buyer out, gives them their earnest money back, and now your seller doesn't want to amend their disclosures.
So it could go either way, right? They could ask for repairs or not ask for repairs, I guess, if they thought it was just too much that scared them away from the house. So
they're going to have to ask for repairs in order to get out of the contract.
Okay.
You can't just submit your termination and say there's just too much here, because maybe the seller is willing to make all the repairs. So you got to give the seller the opportunity at least to make those repairs. And if they decide they're not going to because it's going to cost too much money, then by all means they can let the buyer out of the contract. So I think your question now is with the seller who doesn't want to amend the disclosures because there's another dozen material defects that the inspector identified. That's problematic. I think you need to explain to the seller that now that you have knowledge, even if the seller says, I don't want to disclose it, you've got an obligation now to disclose it because you have actual knowledge of a material defect. So you need to let the seller understand that either you need to disclose it or I'm going to be obligated to disclose it. And if he still insists on not changing the disclosure, I think you cancel the listing contract and say you need to find somebody else, because that's going to put you in a really difficult spot especially if the seller tries to say, don't you dare tell them that my basement floods every time it rains, or that I've got a leak in the roof, and he's putting pressure on you not to disclose that because he needs to sell the house. You're just inviting yourself into a lawsuit.
Okay. So we have a question out of the chat room. Can a buyer cancel the contract if it has an accepted offer and there is water in the basement and the seller does not want to repair?
Yeah, I think what you're going to do is go back to the provision in the contract that says that when we sign this contract, I agree to pay you a certain amount of money for this house in its then present condition. And that condition has materially changed now because 3 days before closing, I go in and you got a foot of water in your basement. So I think if the the buyer can go back and say, hey, we got a problem here. That's a new problem that arose. I don't know that the buyer could do that though if the seller disclosed periodic flooding in the basement and the buyer didn't ask for repairs up front, and now he wants to do that 2 days before closing. But if it's a new condition that's arisen and the seller's disclosure says never had water in the basement, don't have a recurring problem, then it's a new condition that I think the buyer can certainly ask to be addressed. If the seller says, no, I'm not going to do that, then the buyer can terminate the contract and get their earnest money back.
All right. Well, I would like to offer you to join us on June 18th to continue this important subject that really makes or breaks a transaction. And so knowing how to handle this is really important. And we always have questions on it after however many years you've been in the business. Questions come up on this. So what time on June 18th is that meeting?
That'll be at 9 a.m.
9 a.m. Okay. All right, great. Thank you, everyone. And hopefully we'll see you all on June 18th.